source of prosperity. It should create jobs, attract investment, strengthen communities, and expand opportunity. As government, our collective objective is therefore not merely to resolve disputes of the past, it is to create a stronger foundation for the future. The work ahead remains significant. Additional parcels of lands continue to be identified for settlement, and further engagement with communities and leaders remain necessary. But as our intention is clear and our commitment firm, the era in which families lived as squatters and strangers on their land they have occupied for generations is and must come to an end. The chapter in which certainty and security, the chapter in which uncertainty and insecurity defined the lives of our people is and must come to an end. Our promise to the people of Kenya, and specifically those in the coast region, is straightforward.
No deserving Kenyan should continue living in fear on land they call home. We will continue working until justice is delivered, dignity is restored, and every citizen has an opportunity to build a safe and secure future. Sikizeni ndugu zangu. Pwani hoye! Pwani hoye! Nataka mnisikize kwa makini. Leo ndugu zangu, hatujakuja hapa mambo ya siasa. Mnanielewa? Leo tumekuja hapa mambo ya maisha ya watu wa pwani. Shida, tatizo la mambo ya uskwota, tatizo ya mambo ya watu ambao wanaishi katika mashamba, ambao wako hatarini ya kufukuzwa, hatarini ya kuwa evicted. Haya ni mambo ambayo yanaweka familia nyingi, hofu nyingi wakati wanaishi. Na ndio leo nimefika hapa ili tukomeshe kabisa janga hili la uskwota sehemu hii ya pwani. It is a commitment I make, and it is a commitment I have every intention to make sure that I deliver.
Kwa sababu haya ni mambo yamezungumziwa siku nenda siku rudi. Leo nikisimama hapa kwenu, nataka niseme hivi: watu wa Mbaruku pale Kwale, tuko na watu zaidi ya 3,000, familia 3,000, tuko na mashamba familia nyingi. Jumla ya hizi mashamba nimezungumzia hapa ni familia 200,000 ambao wamekuwa wakiishi kwenye mashamba, ambao wengine wako na title deeds. Na mimi wakati niliwaita hawa ndugu zangu watatu, na nataka niwasimamishe: Mheshimiwa Jeffa Kingi, Mheshimiwa Hassan Joho, Mheshimiwa Salim Mvurya. Hawa jamaa watatu niliwaita nikawaambia, ndugu zangu, ninyi nataka muwashirikishe governors wetu wote. Na nataka nimshukuru Mheshimiwa Mungaro, nimshukuru Mheshimiwa Dado kutoka kule Tana River, nishukuru governor wa Lamu, nishukuru governor wa Kilifi, governor wa Mombasa, governor wa Kwale, governor wa Taita Taveta. Niliwaeleza hawa ndugu zangu watatu, mutafanya kazi hii na mimi, na nawasihi na waomba muwe viongozi. Leo nasimama mbele yenu kusema hawa viongozi
ni mashujaa, muwapigie makofi jameni. These brothers, hawa mandugu, niliwaeleza siasa tuweke kando, mirengo tuweke kando, tupange mambo ya watu wa pwani kwa pamoja. Na niliwaeleza hawa ndugu zangu wawashirikishe wabunge wote. Mimi nasimama hapa kuwaambia wabunge wetu
asanteni sana kwa ushirika wenu. Mwapigie wabunge hawa ndugu zetu jameni. I want to ask all the members of parliament. Mara nyingi nimekutana na hawa viongozi. Mara nyingi nimefanya mkutano wa faragha na hawa viongozi. Mara nyingi nimeketi na hawa viongozi.
I wish I could fix this.
Mawaziri wetu, spika wetu Bwana Kingi, magavana wetu na wabunge, kuwaeleza ya kwamba leo tunasimama mbele yenu kuwaambia ya kwamba tatizo la mambo ya ardhi ya pwani sasa tuko na jibu ya hiyo tatizo. We now have the land answer to the land question that has troubled this coast for years. Asanteni sana ndugu zangu, mnaweza keti chini. Sijui kama tunaelewana jameni. Waswahili wanasema mgala muue lakini haki yake mpe bwana. Hawa jamaa wameshirikiana pamoja na mimi. And I told them, hawa viongozi niliwaeleza jambo ambalo lilielezwa na Martin Luther King. I told these leaders, brothers and sisters, what Martin Luther King said. Martin Luther said, we must learn to live together as brothers and sisters, or we will perish together as fools. Mimi sijasema kuna mtu mjinga. Nimesema yale Martin Luther alivyosema. And I want to thank these brothers. Waliamua ya kwamba tutafanya kazi pamoja. Tutashirikiana pamoja. Sio kwa sababu ya mtu fulani, lakini kwa sababu ya watu wa pwani. And I want to say in front of this great multitude, to my brothers here, thank you very much for closing ranks, for working together, for being united so that we can deliver on this most consequential assignment given to us by the people of Coast Province to sort out the squatter problem, to sort out absentee landlords. And I must say this, tuko na wananchi pia, na mimi nataka niwashukuru wale tuliwaita absentee landlords. Wamekuwa na title deeds, wako na eviction orders, wako na mambo mengi, lakini wakati tuliwauliza ya kwamba tutatue tatizo hili kwa njia ya amani, kwa njia ya mazungumzo, pia na wao walikubaliana na mimi, wakakubaliana na sisi. Mimi najua wako hapa wengine wao, tafadhali msimame. These are great people. Tuwapigie makofi jameni hawa wangwana. Hawa wangwana wamekuwa wazalendo wa taifa letu la Kenya. Wameamua ya kwamba mashamba ambao wamekuwa nazo, wako na title deeds, wako na eviction orders, wako na mambo yale mengine yote, lakini waliamua tatizo ama suluhisho haitakuwa kwa mashindano na kupigana na kupelekana makotini. Suluhisho iko katika mazungumzo ya umoja na kutafuta vile tunaweza kutatua tatizo hili. So let me say this. Mimi nimefurahi sana kufika hapa leo. Na leo hapa, haya mashamba yote ambayo nimeyasoma hapa, tayari tumepatiwa hati miliki. We have title deeds. Ile sasa tutafanya kutoka hapa. Leo I am instructing the Ministry of Lands, waende sasa wakatekate mashamba haya yote. Kila mtu apimiwe. Unasema tuendelee ama tuendelee? Mimi nataka niwahakikishie watu wa pwani, munisikize vizuri. Mimi nimeamua ya kwamba hatutaki taifa ambayo imegawanywa kwa misingi ya ukabila na chuki na mambo ya kupiganisha wananchi. Taifa la Kenya ni taifa moja. We have enough to share amongst the people of Kenya. We do not have enough for anybody's greed, but we have enough to satisfy every Kenyan. Na ndio nimesema ya kwamba vile tulikubaliana na Mheshimiwa Raila Odinga, tukasema tunatengeneza serikali ya broad based, serikali ya kuunganisha Wakenya wote, serikali ya kuondoa ubaguzi, serikali ya kuondoa ukabila, serikali ya kuondoa chuki, serikali ya kuunganisha Wakenya wote na kuhakikisha hakuna sehemu ya Kenya, hakuna jamii ya Kenya itawachwa nyuma katika mipango ya maendeleo ya taifa letu la Kenya. Leo nasimama hapa kusema broad based imetufanya tukawa na maafikiano na tukawa na suluhu ya mambo ya mashamba na suluhu ya matatizo mengine ya taifa letu la Kenya. And I proudly say we are committed to making sure that broad-based government delivers to the people of Kenya. That is the spirit of unity, the spirit of working together, ndio itatusaidia twende mbele kwa pamoja. Mombasa hoye! Mombasa hoye! Mimi nataka nimalizie. Nimeona asubuhi ya leo watu wa Mombasa wakivuka feri hapa. Mimi nataka niwaeleze wangwana wa Mombasa na kule Kwale ya kwamba tunawatengelezea feri nyingine kabla ya Disemba. We have committed 3 billion shillings. By December, we will have a new ferry to reduce the congestion here at this ferry. Na pia kule Mtongwe, we are investing another 500 million to make sure that mobility is improved in this Mombasa County. Munasema tuendelea hapa kesho. Niko hapa kesho kutwa. Hapa tena Jumapili. Hata Jumatatu niko area. Tunaelewana? Munasema tuendelea ama tuendelee? Nasema tuendelee ama tuendelee? Watu ambao mnawajua wale hawa. Pia kule Mtongwe, we are investing another 500 million to make sure that mobility is improved in this Mombasa County. Munasema tuendelee ama tuendelee? Mimi niko hapa leo, niko hapa kesho, niko hapa kesho kutwa, niko hapa tena Jumapili, hata Jumatatu niko area. Kwa hivyo muanze kunizoea bwana. Mimi niko area. Tunaelewana? Munasema tuendelee ama tuendelee? Munasema tuendelee ama tuendelee? Na msijali na wale ni watu ambao mnawajua. Wale hawaelewi chochote. Wale mpango hawana. Wale sera hawana. Wale agenda hawana. Hata akili hawana. Wale msijali na wao. Sijui kama tunaelewana. Tunaelewana jameni? Wale mambo yao ni matusi na ukabila na chuki na kutuita majina. Lakini mimi nataka niwaeleze haya yote, kutuita majina, matusi, ukabila, haiwezi kututisha, kwa sababu tumeamua Kenya tunatembea kwa pamoja, na kila kiongozi anapimwa sio kwa matusi, anapimwa sio kwa ukabila. Kila kiongozi anapimwa na ile kazi amefanya, na ile mpango akonayo, na ile track record akonayo, na ile maono akonayo. Ni kweli ama si kweli? Ni kweli ama si kweli? And I want to say, without fear of any contradiction, while I am here at the coast, for those of you who are visionless, the people who are agendaless, the people who have no vision for our nation, the people who have no plan for our nation, the people who have no agenda for our nation. You will not divide our nation using ethnicity. You will not divide our nation using hate. Hiyo mnafanya, the hate you are spewing. I want to tell you, one day, you will answer for the tribalism you are perpetuating in Kenya, for the hate you are perpetuating in Kenya. The life of Rachel Wandeto will not go unanswered. You who call others traitors, you mwenye mnawaita Wakenya wengine wasaliti, mpaka mama Rachel Wandeto ameuawa kwa sababu ya chuki yenu, kwa sababu ya ukabila yenu, kwa sababu ya profiling ambayo umefanya Wakenya wengine eti ni wasaliti. Siku moja mutajibu, na Kenya hii hatuwezi kukubali, hatuwezi kuwaruhusu mtuuzie ukabila, mtuuzie chuki, mtuuzie blackmail. We are telling you, we will not allow you to blackmail anybody in Kenya. You will not blackmail our nation using ethnicity. You will not blackmail our nation using hate. You will not profile citizens as traitors because they don't believe in your tribal bigotry. We are going to stand together as a nation, and one day you will answer for what you are doing. Our nation will not go forward, our nation will not go backwards, our nation will move forward with unity, because we are one nation, one people. With a common destiny, and Kenya is going to move forward. Tuendelee ama tuendelee? Kenya tuendelee ama tuendelee? Hebu nione wanasema tuendelee. Jameni, Wakenya hoye! Ati Mombasa mnasemaje? Ati Mombasa mnasemaje? Mnasemaje? Ati Pwani mnasemaje? Ati Pwani mnasemaje? Asanteni sana, Mungu wabariki na wapenda sana. Thank you very much and God bless you.
Hebu tumpo Rais kwa makofi tafadhali. Mheshimiwa Rais, tunaomba ubaki ili tuweze kupeana hati miliki kadhaa ili ziwe kama sample ya zile 33,000. Naomba wale tuko na viti tafadhali tuketi, na ni mwalike PS aje na pia governor aje ili tuweze kupeana hati miliki, na tuanze na Mombasa County. Nataka Mombasa County, tumpigie makofi tafadhali, akifuatwa na Stella Makungu Amakanga, na twende teketeke. Anthony Ngugi Ngunjiri, Martha Wakio Mwamboa, Abel Kamainga. Hao ni wa Mombasa County. Manoni wametoka upande wa Manoni tu. Haya basi, tukiendelea, Coleman Kambona, Masao, Anthony Ngugi Ngunjiri, Anthony, alafu Martha Wakio Mwamboa, Martha. Abel Kamainga Omoi, then Coleman, alafu Masad, Masad, then Jennifer, John Otieno, alafu Mariam Shekeli, Sidi Saidi, Hadija, Sidi, Hadija Mushin. Haya, alafu Hamisi Ali, Juma Abdalla, haya, alafu Weru Settlement, Abubakar Omar, Charo Toya, basi tunaenda kwa Abubakar Omar. Huyu ni wa kutoka Weru Settlement, akifuatwa na Charo Thoya Mwatela, Sara, Sara. Basi endelea. Basi Kaingu 0, tungoje kidogo. Janet Dhahabu. Janet Dhahabu pia wapewe hatimiliki yake. Changawa. Changawa. Shaban Juma. Kache Nyundo basi anapewa yake akifuatwa na Suleiman Shaban Juma. After Suleiman tuko na Nyasha. Hilda, niko na Hilda. Hilda Wanjara. Ni Hilda Wanjara. Haya. Hilda. Hebu simama kando kidogo. Alafu
Hogla wakio. Hogla wakio.
Huyu ni alafu Hemed. Sorry? Hemed Salim Juma. Esimili sawa. Juma. Esimili. Samuel. Sikujua. Haya basi anafuatwa na Samuel sikujua, lakini Samuel anajua. Ni jina ndio hakujua. Mwachia. Alafu Elmas. Alafu Anthony Gari. Simama. Alafu Hogla Wakio. Sasa ndio amefikiwa. Kazungu Koi. Hogla Wakio Mwachala basi akifuata na anafuatwa na Kazungu Koi Charo. Basi tuko kwa Hogla Wakio anafuatwa na Kazungu Koi Charo. Haya basi Francis Mwanzia afate. Alafu Hamisi Charo. Basi akifuatwa na Eliud Chiwado. Ngoja. Eliud Chiwado. Alafu Nancy Nazikiti. Nancy huyo ni Nancy, alafu Charles Dena Chingu, Suzeni Bahati Julia, Suzeni Bahati, akifuatwa na Oliver Mwandonyi, alafu tumalizie na Sami ambaye yatashughulika na hii kazi ambaye ni ya kugawa mashamba ili kila mmoja aweze kupata haki yake. Kwa hivyo sasa Mheshimiwa Rais anakuja ili tuweze magari yameondoka yaende yaweze kufanya kazi vinavyofaa. Basi rais akishika bendera pale, in 3, 2, 1, wapi makofi ya rais?
Yes, yes.
Sasa magari yako hapo yote yakienda safari ya kuhakikisha kazi imetendeka na inafanyika. Asante sana Mheshimiwa Rais. Kwa sasa naomba tutamalizia kwa wimbo wa taifa, kwa hivyo tusimame wima ili tuweze kumalizia kwa wimbo wa taifa.
Kote nchini mbele
Kenya, twende mbele. NCBA, go for it.
State security and public office to influence voters. I have not found any. What I find in this case is that there is evidence that CS Ruto, together with Embu governor and other public officers, were mentioned by witnesses as intimately involved in the campaigns leading to election day. It is probable, but not proved, that these officers were using state vehicles or state resources for transportation during the election period. They may also have used state resources such as police personnel. There is clear evidence that enhanced police presence was noted by many witnesses. That is also clear from the videos played in court, where in some cases, vehicles with no number plates were seen. It is also likely that by virtue of the power, stature, and influence of their public offices, these officers could readily command attention of or influence voters. No evidence, however, has been adduced concerning actual abuse of office and improper influence by any particular state or public officer. It was incumbent upon the petitioner, in order to prove issue 7, to provide at least the following evidence: names of the public officers, this they did, a number of them, their designations and offices held, and particulars and nature of the alleged abuses of such offices, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced, and accordingly, I am unable to find in his favor on this issue. Issue number 8. Whether there was delay in counting votes, exclusion of agents, defective and falsified statutory forms, opaque counting and tallying in violation of Article 86 of the Constitution and Regulation 79 of the Elections General Regulations. With regard to delay in counting votes, the only evidence presented related to Gitiburi 1 and 2 were the breakout of the fire affected the timely counting of votes. Regarding exclusion of agents, the only evidence was that of PW6, who alleged that he was handcuffed and detained in a police vehicle until 8 p.m., hence was denied a chance to witness counting of the votes. From the DR scrutiny reports, agents of the petitioner were present in the stations where scrutiny was ordered, and they signed Forms 35A. With regard to defective and falsified statutory forms and opaque counting and tallying, the allegations in the petition were that Forms 35 were overwritten, resulting in opacity of results. In respect of Keria Polling Station 2, Nazario Mugo, who was the PO, did not testify on the inconsistencies between Forms 35A and 35B, showing a total number of votes obtained and cast as 225 and 223 respectively, a difference of 2 votes. I looked at the form carefully, the Forms 35. The tally on the right-hand side for each candidate is indicated as in a total. That figure is supposed to be translocated to the column on the left-hand side, and the 2 should tally. So the key figure that is of interest is the one on the right-hand side, not the translocated figure. In respect of Gitiburi 2, RW3 Lydia Kamau, the PO, did not testify on the inconsistencies between Forms 35 and 35A and 35B, which indicated that the number of valid votes obtained and cast is 261 and 262 respectively. However, during scrutiny, the votes were recounted and the number of valid votes cast remained 262, meaning that Forms 35B was erroneous by 1 vote. In respect of Mushonoke 2, Timothy Nyaga Maringa, the PO, did not testify on inconsistencies between Forms 35A and 35B, showing 304 and 303 votes respectively. on the number of valid votes obtained and cast. Scrutiny was not done for this station, and the inconsistency of one vote remains unexplained. At Kamugu Polling Station 2, Form 35A indicates the number of valid votes obtained as 449, which is where the tally for each candidate is indicated. Whereas in the section of polling station counts, at item 5, the total number of valid votes cast is indicated as 456. This is on the left side of the form 35. And the total rejected votes are indicated as 7. Shadrach and Nyaga and Jagib, the PO at this polling station, did not testify, and no further explanations were made regarding this inconsistency of 449 and 456 votes. On this latter inconsistency, it appears likely to the court that the 7 votes difference is attributable to the total rejected votes being carried to item 5 and added to the votes obtained. These unexplained inconsistencies in these votes, all these forms 35 that I've referred to, these unexplained inconsistencies, I should say, add up to 10 votes in forms 35. Add up to 10 votes in forms 35A, a difference of 10 votes in forms 35A and 35B, so that the election result has a 10-vote difference, unknown as to whom those votes would benefit. The scrutiny did not find anything to suggest any irregularity, but rather careless mistake in translocation from the vote tally column of Form 35. 35A, Form 35A. Regarding allegations that some 37 Forms 35A were overwritten and not countersigned, the court allowed scrutiny of only 8 of them where such overwriting demanded scrutiny. The DR's scrutiny report, dated 17th April 2026 at pages 21 to 24, found that despite overwriting, the figures added up to the total valid votes as in Form 35A. There was no major discrepancy noted. The court agrees that the overwriting did not result in any discrepancy, and the irregularities cannot be said to substantially have affected the will of the people. The will of the voters, not the people. The petitioner also complained during the hearing about errors on Forms 32 in respect of assisted voters. I have had to deal with this issue because it arose during evidence repeatedly. At the outset, it is essential to note that the issue of assisted voters was not pleaded, either in the petition, in the petitioner's issues, or in the grounds of relief. It featured, however, in the supporting affidavit of the petitioner. In one paragraph, we'll get there, and in some of the other affidavits of the petitioner's witnesses, and also in witness testimony. In paragraph 94 of the supporting affidavit to the petitioner deposed as follows: that further, the said agents would bribe the voters on condition that they declared that they were illiterate and in need of assisted voting. This led to exhaustion of oaths of secrecy forms due to inexplicable influx of persons allegedly in need of assisted voting. The second respondents filed an affidavit in support of the response to the petition. The first to third respondents did not respond specifically to the allegation made under paragraph 94 of the supporting affidavit of the petition, even though on their behalf the second respondent acknowledged as follows: that I have read and been explained to by Charles Benedict Mungela, counsel on record, for the first, second, and third respondents, the election petition dated 22nd December 2025, and the affidavit in support of the election petition, sworn on 22nd December 2025 by Ndwiga Newton Kariuki, and wish to respond as follows. So the issue became sort of subsumed through the affidavits. In furtherance of his claims on assisted voting, the petitioner during his testimony on numerous occasions reiterated his claim on bribery and assisted voting, which featured in his supporting affidavit. Other witnesses of the petitioner, for example PW10 and PW11, considered that as they were accepting bribes, others in the group and in the premises at the house of Edward Njage, where they were also accepting bribes to become assisted voters. PW9 Julieta Kidhumbu testified that she saw many assisted voters at Muchonoke Health Center 2 polling station, where she was the agent. She said that there were mobilizers who brought assisted voters to the station. In one case, she saw an assist 4 voters. And she complained to the PO, but did not record the fact in her notebook, though she signed Form 35A without objection. The issue of assisted voters became pronounced after the court ordered that election materials be preserved into the custody of the court and the DR to make a detailed report on the movement. That's the movement of the materials. The record of that movement of materials
rahisi hivyo tu wa pesa. Mkopo rahisi wa pesa papo hapo.
High Court. The report is dated 27th January 2026. In it, the DR recorded having received the following boxes from a strong room of IEBC offices in Embu. 134 ballot boxes, namely one from each polling station. One box captured as the 135th ballot box delivered at the tallying center. 4 boxes recorded in an, quote, inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, unquote. And finally, 15 boxes containing Kim's kits. Of the 4 boxes in the inventory of other strategic materials issued to Embu High Court for the Mbeere North by-election petition, that was box number 114337, it contained, amongst other things, 1,072 Forms 32, declaration of secrecy, made by a person assisting a voter. Naturally, this inventory raised concerns as to why these materials were produced from the IEBC offices at Embu without any record by the returning officer. Accordingly, in its ruling, paragraph 62 and 4, 62.2 and 4, delivered on 27th March 2026, the court ordered scrutiny of other strategic materials issued to Embu High Court. Following scrutiny by the DR, she reported her findings at page 15 to 19 of her report of 17th April 2026 as follows: that there were 1072 Forms 32, folio marked 1 to 1072. Out of these, 10 were blank or unpopulated in any way, blank forms. There were forms by 6 declarants which had filled forms, by 6 declarants who had filled forms twice, of whom 2 declarants filled 2 forms at 2 different polling stations, while the other 4 declarants each filled 2 forms at 1 station. That is all contained in table 4 of that report. RW1 testified that at the tallying center, he received 134 ballot boxes. He also stated that he handed over to the DR 135 ballot boxes, with 1 box containing strategic materials. He stated that he prepared box 135 out of good faith. He gave no explanation for any of the other boxes. According to the IEBC polling station diary template, Forms 32 from each polling station where voters were assisted were required to be put in a tamper-proof envelope and handed over to the returning officer. However, during scrutiny, all Forms 32 were found unsealed and loosely filed in a box file in box number 114337. The foregoing handling of Forms 32 shows a rather casual approach to a very important act of verification and secrecy relating to assisted voters in exercise of their right to vote. Added to that casualness, there was the neglect and failure to record the same in the register. Indeed, there was no way of accounting for these forms, for example, either in the polling station diary or in the voters' register. The stipulation of the law on aided voters is found at Regulation 72(6) of the Elections General Regulations, which provides as follows: where a presiding officer grants the request of a voter under this regulation, the presiding officer shall record in the polling station register against the name of the voter the fact that the voter was assisted and the reason for the assistance. It was not contested that the physical voters register that was deployed was contained in a sealed tamper-proof envelope, and that it was never physically opened, but was only used to open the KIMS kit through the QR code. What requires interrogation is whether an election court may assess or make determination on irregularities or illegalities revealed during scrutiny or recount where such matters were not specifically pleaded. My understanding is that what is required is a continuous balancing between two competing constitutional and procedural imperatives. On the one hand is the cardinal rule on adversarial litigation, that parties are bound by their pleadings, ensuring procedural fairness, certainty of issues, and protection against trial by ambush. On the other hand, there is the constitutional duty imposed on election courts to safeguard the integrity, verifiability, accountability, and transparency of elections under Articles 86 and 81 of the Constitution. It is a substantive rule of adjudication that pleadings have a binding force. In IEBC versus Stephen Mutinda Mule and others, the Court of Appeal stated in unequivocal terms that parties are bound by their pleadings and that evidence which departs from the pleaded issues goes to no issue and must be disregarded. The same logic was reiterated in Raila Odinga and 5 others, Supreme Court petition number 5 of 2013. There, the Supreme Court emphasized that parties are bound by their pleadings and evidence must be confined to pleaded issues. Similarly, the Supreme Court in Zachariah Okoth Obado and Edward Oyugi, Supreme Court petition 37 of 2014, reinforced the position that election petitions are strictly framed disputes. Respondents are entitled to know with precision the case they must meet, and the court is equally constrained by the issues framed in the pleadings. This establishes pleadings as the primary jurisdictional boundary of electoral adjudication. Against this strict framework, the Supreme Court in Gatirao Peter Munya versus Dixon Mwenda 2014 set out the governing logic on scrutiny, which is that scrutiny is not a fishing expedition. It is a verification mechanism tethered to pleaded allegations. The court was clear that scrutiny cannot be used to discover new causes of action or to sustain a petition that fails on its pleaded grounds. However, the court also recognized a controlled opening, namely that where scrutiny is properly ordered, particularly by the court itself, as in this case, what emerges may be interrogated by the parties and evaluated for its impact on the integrity of the result. Can courts therefore ignore serious electoral irregularities that emerge from scrutiny? Where scrutiny is triggered by a party's application, its scope is strictly confined to the pleaded issues and the specific polling stations in dispute. It cannot be used to enlarge the petition or introduce new grounds of challenge. Yes, several cases cited. By contrast, where scrutiny is ordered suo motu, which is I think what this court did, the court may direct scrutiny as part of its case management powers to clarify the evidentiary record, but this does not expand the issues for determination or convert scrutiny into an inquisitorial process. Any irregularities emerging from the scrutiny remain subject to contestation by the parties and must be evaluated within the pleaded issues and the constitutional standard of electoral compliance. The question whether the court should turn a blind eye on malpractices arising from scrutiny was focused on in the Musikari Combo case, 2014, where the court held that an election cannot turn a blind eye to serious electoral malpractices revealed during scrutiny or recounts simply because they were not pleaded. The court justified this exception on constitutional grounds that electoral justice cannot be reduced to procedural technicalities where the process itself is shown to be fundamentally compromised. In Peter Kingara versus IEBC 2014, the Court of Appeal emphasized that scrutiny is not an avenue for building a new case. That position was reaffirmed in many other cases, and I've cited a number of them. The courts have reiterated that scrutiny must remain tethered to pleaded issues unless exceptional procedural safeguards exist. That caution was emphasized also in Walter Nyambati case, 2018, where the Supreme Court stated that scrutiny is not a fishing expedition, cannot be used to latch onto whatever evidence to construct a case not pleaded. I've cited Abdikadir Hussein's case, the 2023 High Court. Kenya Court of Appeal, where the Court of Appeal introduces a decisive procedural safeguard that even where serious irregularities are revealed by scrutiny, an election court cannot rely on them without first placing the adverse party on notice and affording an opportunity to respond. The court treated this not as a discretionary courtesy but as a requirement of due process, and pleaded material cannot silently or automatically mature into grounds for nullification. In the present case, and as already pointed out, the issue of assisted voters featured significantly in the petitioner's supporting affidavit and upon hearing of the evidence of the petitioner's witnesses. The respondents thus had a full opportunity to deal with the issue. It was evident as far back as was recorded in the DR's report on movement of the preservation materials and in the petitioner's witness affidavits. There was no ambush, in my view. In its decision in Kombe versus Karisa and three others, 2024, Kenya Supreme Court, the Supreme Court affirmed the core principles in Munya on scrutiny. The Apex Court stated as follows at paragraph 107, the Court of Appeal relied on the decision of the Supreme Court in Munya that scrutiny is a vehicle to assist the court to verify the allegations made by the parties to the petition, which allegations themselves must be hinged on pleadings, that it was never intended to enable the court to unearth new evidence on the basis of which the petition could be sustained. From the record, the Supreme Court accepted that the trial court had engaged extensively with scrutiny findings such as unstamped counterfoils, polling station inconsistencies, and irregularities in statutory forms. The Court of Appeal had criticized reliance on some of these matters as unpleaded. The Supreme Court's reaction was not to abandon the pleadings rule, but to recharacterize the function of scrutiny evidence within the broader because they were not expressly and specifically pleaded. At para 108, the Supreme Court noted as follows, it would appear therefore that the report of scrutiny did not yield the outcome expected by the first respondent when he sought it. That did not preclude him from presenting and relying on other pieces of evidence to illustrate that the election in question did not conform with the constitutional and legal imperatives. In the present case, the question of assisted voters was not specifically pleaded, as already stated. Nevertheless, it does not arise as entirely as an ambush. Since the petitioners supporting affidavit and the first to third respondents replying affidavits took notice of the issue. When the court ordered scrutiny of the assisted voter forms, this emanated from the fact that they were produced for preservation without any record as to how they found their way into the box and files. They were delivered in. The court was thus entitled to order scrutiny thereof, since oral evidence had been taken and no proper account of the Forms 32 had been given by the respondents. Thus, scrutiny was duly ordered and forms part of the evidential matrix. In my view, the outcome of the scrutiny may be used in evaluation of whether the totality of the electoral process met the constitutional threshold of integrity, verifiability, and accountability. The decisive question is not whether each irregularity was individually pleaded, but whether the election, taken as a whole, complied with the constitutional and statutory standards. The authorities hold as follows, and I've cited Mohammed Abdi. Let me read it. Where the Supreme Court majority refined the remedial approach to Regulation 72, non-compliance, by requiring that such breaches be assessed within the broader Article 86 framework of verifiability and materiality, rather than be treated as automatically determinative of electoral invalidity. Where in the first instance the failure to mark the register is isolated or inadequately proved, the courts generally decline to nullify elections, although the failure weakens the credibility of the official account. This was the position in Mohammed Mahmoud Ali versus IEBC, Mombasa High Court 2017. Further, if the failure becomes systemic, particularly in constituencies where assisted voting would predictably be widespread, courts may infer that the process itself became unverifiable. In light of the foregoing analysis of the law, this court can now make the following conclusions. First, that Regulation 72(6) of the Elections General Regulations was violated in respect of the 1072 assisted voters, as they were not recorded in the physical register as required, nor was there evidence that they were indicated as such in the KIMS register or PSD. Secondly, that the only evidence available that there were assisted voters is the existence of Form 32, which is the declaration of secrecy, in compliance with Regulation 72(5), indicating the declaration of secrecy by persons that assisted the said voters. Thirdly, with regard to double declarations by the 6 declarants earlier discussed as found during scrutiny, these were in breach of Regulation 72(5) of the Elections General Regulations, which provides that as follows: the following shall apply with respect to a person who assists a voter under this regulation. The person shall assist or support only one voter at that election and have a mark as proof of assisting or supporting a voter. Fourthly, while the court take the position that all assisted voters' votes be struck off, it would not change the result of the election, as it is impossible to identify for which candidate they voted. Finally, taking into account the caution of the superior courts concerning unpleaded issues and considering these violations cumulatively with the other irregularities pleaded and on which evidence was availed and has been evaluated, I am not satisfied that it was ultimately shown that the results did not reflect the will of the people in relation to assisted voters. Conclusions and disposition. On issue 1, the court found that the evidence of the petitioner did not list the IEBC officers in issue, did not identify which of the officers were opaquely. Actually, I've just reiterated, I've plucked from the body of each conclusion, I brought it back to the conclusions and disposition. So that on issue 1, I find that no qualitative disqualifying attribute in appointment and dismissal of IEBC election officials was demonstrated. On issue 2, again, I plucked the conclusion I reached under that issue and brought it forward. It was demonstrated by evidence that there was a physical register, voters register available at every police station, that it had a QR code, that the KIMS kit had a soft copy replica of that register, No evidence was availed that any voter was disenfranchised, since the physical registers were present and were also replicated in the KIMS kit. Then I point out the jurisprudence on the use of the physical register is essentially what is carried in the UDA case, that such register is only to be used in instances where biometric or alphanumeric identification fails. The UDA case, I may say, does not entirely deal with Section 72, Regulation 72. It doesn't entirely with regard to assisted voters. There was no evidence of such failure of identification. The prevailing jurisprudence on the use of registers is the UDA case, is that such register is only to be used in instances where biometric or alphanumeric identification fails. There was no evidence of such failure of identification. Had there been a failure of biometric and alphanumeric identification, followed by failure by IEBC to deploy the physical register, a case of voter disenfranchisement would have been readily made out. On issue 3, whether there was unlawful third-party interference, on this I came to the conclusion that it was not proved that admitted interference with the register was either widespread, systemic, or intended. In substance, therefore, there was no proof that of the fact that the sole instance of interference that we saw in the case of Collins affected the will of the people. It was also held that in the case of one individual, where the register was shown to have been unlawfully altered, the officer involved may have committed a criminal offense. On issue 4, the same summary that I take the same summary or conclusion, and this is where I said Kaungu theoretically suffered a turnout decrease of about 8% or 51 voters as against the constituency average. But I found overall the failure did not affect the outcome in terms of Section 81 of the Elections Act. Section 82, sorry, of the Elections Act. On issue 5, whether there was bribery treating, maybe I just read all of them. If you don't mind, let me just read all of them so that I don't give an impression. On issue 5, whether there was bribery, treating, and undue influence in violation of the Election Offences Act and the Constitution, there was uncontroverted evidence of bribery involving 2 witnesses. As an election court, this court can make a determination only on whether the election malpractice, whether an electoral malpractice of a criminal nature may have occurred in terms of Section 87 of the Election Act, but not on whether the offence of bribery was committed. I do find that an electoral malpractice of bribery may have occurred. As to whether the electoral malpractice of bribery and voter influence so found results in the nullification of the election, the evidence does not show that the scope and prevalence of the malpractice substantially affected the result of the election in terms of Section 83 of the Elections Act. On issue 6, whether there was broken chain of custody, unlawful handling of election materials, and violation of procedure on close of polling, the totality of the evidence availed disclosed that out of 134 polling stations, there was broken chain of custody, possible unlawful handling of voting material, but no violation of poll closing procedure at Gitiburi 1 and 2, except with regard to the time. For Kaungu, there was evidence of violence, but no evidence of broken chain of custody, unlawful handling or violation of poll station closing procedure. Consequently, there is no basis for a finding that the irregularities or non-compliance were substantial and affected the election outcome in terms of Section 83(1) of the Elections Act. Had it been demonstrated that the sort of violence shown at Kaungu was pervasive or widespread, a positive case would have been made out to conclude that the violence affected the overall quality of the election and had a significant impact on the result. Issue 7, on whether there was use of state resources, state security offices to influence the voters. it was incumbent on the petitioner, in order to prove issue 7, to provide at least the minimum information or proof, the names, some of which were provided, their formal designations, offices held, and particulars and nature of the alleged abuses of such offices, provisions of the law breached, and the overall effect of such abuses upon the electorate and the election outcome. The petitioner failed to provide these through the evidence adduced. Accordingly, the court is unable to find in his favor on this issue. On issue number 8, the court was unable to find in favor of the petitioner, the same on even the assisted voters, because with the assisted voters, what I have done is that I have said I take seriously the caution by the superior courts concerning unpleaded evidence gathered through scrutiny. The outright determination, the overall determination, for all the foregoing reasons, the court finds that the petition was not proved to the required standard, and it is hereby dismissed with costs. The costs are as follows. The parties made submissions on costs, generally to the effect that costs follow the event. The first to third respondents' counsel went into some fair detail in indicating the depth of the case, the number of attendances, preparatory time, complexity, and so on. The first to the third respondents and the fourth respondents both indicated that costs should be at Kenya shillings 5 million. The petitioner only submitted during highlighting. So having considered the nature of the case and the input of the parties, and noting the fourth respondent did not testify to or avail witnesses, I hereby cap party and party costs at Kenya shillings 4 million. The first to third respondents shall be entitled to 70% thereof, and the fourth respondent to 30% thereof. I have prepared a report of the court on electoral malpractices under Section 87 of the Elections Act, which is as follows. The court finds that the following malpractices of a criminal nature may have been committed and directs that the same be transmitted to the DPP. A. Admitted alteration of register without authority, contrary to Section 6(1) of the Election Offences Act. B. Double assistance of voters, that is allowing 6 persons to assist more than one voter, each contrary to Regulation 72(5)(c) of the regulations. C. Failure to record in the polling station register against the name of the voter the fact that the voter was assisted, contrary to Regulation 72(6). I will make recommendations separately. I will not, because there's no point of putting the recommendations in the judgment, but I'll make recommendations separately, particularly for IEBC's notice, subsequent to this judgment, because I think it is important. Certificate of court as to validity of the election under Section 86 of the Elections Act. Having concluded the hearing of the election petition, I certify that the petition was dismissed and the fourth respondent remains the duly elected member of parliament for Mbeere North constituency. This information is to be transmitted to the Speaker of the National Assembly. Orders accordingly.
Yeah, my Lord, we are most obliged by the decision of the court. We have sat and listened to it. We appreciate where the court is coming from, but we, however, would wish to make an appeal in regard to some of the issues the court has dealt with. And therefore, my Lord, we are making an application for expedited provision of typed proceedings, the judgment of the court, and the decree accruing therefrom. Your Lordship, the reason for the appeal is, my Lord, that this might be the only time the certain issues will be clarified by the Court of Appeal. Most importantly, the question of the alteration of the voters register. And my Lord, since I am not making an appeal before you, would wish to make the Court of Appeal pronounce itself. Number two, Your Lordship, on the question of the scrutiny that was dealt with by the Deputy Registrar. My Lord, we have listened to you and the judgment, and we note that the judgment itself does not capture the entire report as reported by the Deputy Registrar, and most importantly, in respect to ballot box number 35 and the 212 votes that were cast in foil. We have not heard you pronounce yourself on that, Your Lordship. Would we therefore wish to make an appeal? And then, my Lord, I don't know how that will square out, because it has not been captioned in your judgment. Because, my Lord, when you ordered,
it should be easy enough, because the proceedings of the registrar will be part of the proceedings of the
yes,
court.
my Lord.
So you just annex them and say that the lower court failed to deal with an issue.
My Lord, we will be obliged. We are otherwise happy that the court has made its decision. We'll try our luck in the Court of Appeal. We are most obliged.
Fortunately, the judgment is typed already.
Yes, my Lord.
The proceedings are typed, so it should be fairly easy to get the record fairly quickly.
We will get it, ma'am.
Yes,
my Lord, Kirago Aduta, and I thank you for that judgment. My Lord, I just have one request, and as we review the judgment, so that then we can see what we make of it in terms of what is the next step. We just like to make an application for stay of execution on the issue of costs, because we know we have money in court. Yeah, so that, my Lord, the issue of costs may be given about 30 days for us to review the judgment before the money is released, if such an order is sought, so that then we can make the appropriate application, if any, upon taking instructions. So that, my Lord, if, as Mr. Ndegwajiru mentioned, if there is any need for review or clarification from the court, then we can have that period to consider all those options. That's all, my Lord. Yeah, I'm being informed that I seek 45 days, kindly, my Lord. 45 days, my Lord. That's all, my Lord. Thank you.
He's asking for 45.
Yes, I hear you, my Lord.
Yes.
We wouldn't be opposing the request for stay, my Lord. There is no indication upon which such a stay would be predicated, my Lord. No appeal has been filed as yet. Even the costs have not even been ascertained. My Lord, on the second issue, the IBC takes note of the issues you have raised, and they welcome the report which you will be extracting and sending them from this judgment, my Lord, which is going to inform the improvement. The improvement in terms of how they conduct their affairs and how the elections can be improved better. Otherwise, my Lord, on behalf of the electoral body...
Let me summarize it.
Yes, my Lord. Yes.
Just sit down. During the hearing of the case, almost without exception, every IBC officer who gave testimony asked, did you report? He also said, Was this outside the polling station? Did this occur outside the polling station? I gave a long introductory discussion about the powers of IEBC because it is important for IEBC to remember that during or in connection with anything to do with elections, IEBC is the policeman of Kenya. It's not the Kenya police. So that you cannot wring your hands and say it was not reported, you don't have an OB. No complaint was made. You have seminal powers. IEBC. You have powers as a commission, even to investigate. You just need to read the newspaper. You hear something occurred, you run. Just like the Kenya Revenue Authority. When they hear ching, 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 in your mobile phone, they come running. That is how ABC is supposed to operate under this constitution and the laws. So that is one of the big areas I'll be discussing in the recommendations.
Yes, madam.
In India, it is clear that IEBC behaved, sorry, not IEBC, the Electoral Commission there behaved the way IEBC behaves today. They changed. They became proactive. The code of conduct is enforced in India. And in fact, in India, the petitions are very, very few. I was there myself, personally. There are hardly any petitions because IEBC does its work. Yeah.
Well, my lord, while you're still on that,
now this is not part of the judgment.
That's correct, my lord. It's also my observation. And my lord, the reason why we would wish to have some of these issues clarified, would not wish, my lord, even to disturb that kind of finding, because, my lord, this is the first time I have had an election court making such kind of pronouncements in respect on how the IBC is supposed to conduct. So, my lord, even when you hear us making an appeal, we just want to make sure that we buttress some of those issues that you have said in your judgment.
But you will notice that in discussing the powers of IEBC and its authority, this was not in respect of an issue for determination. So all that is mostly, what you call it, what, obiter?
No, it's not obiter, because you're supposed to pronounce yourself in a manner that the law also speaks. It's not obiter.
All right, anyway, you will take the judgment to the next court. But what worries me is what I see every day happening. Because we are all Kenyans. We see things that occur. We hear when there's an election petition or an election, in any part of the country. It's reported in the newspapers. There are clips from all sorts of places. We don't believe everything. But we are able to get the general mood of people. And that mood.
Mi naitwa Peter Kivenji na mimi ni dereva wa matatu. Furisha mara ya kwanza sikuwa naamini kama ni ukweli, lakini wakati nilienda kwa simu ikakuja ilikuwa kujaribu. Na nikaona na ni kweli imeingia. Kama kuna wakati mtoto alikuwa amefikishwa shule, nikaona kuliko kwanza akunje nianze kushughulika na atatumia fare kutoka shule kufika huku na tena atarudi na ni lazima arudi na ile pesa. Nikakumbuka niko na furisha, nikamfurishia haraka akaendelea kukaa huko. Hapo ikaniokolea sana. Maliza mambo yako na furisha.
Of IEBC. That's one of the things I want to recommend. I can't recommend those things here because it wouldn't make sense. But there must be some kind of inspectorate. I don't know how Kenya Revenue or Kenya Anti-Corruption Commission, how they do it. But however they do it, they seem to be fairly effective. That's what we want with IEBC. Because the Constitution guarantees us a free and fair election. It guarantees Weveti that when she's going to her polling station, nobody is going to sumbua. No masumbuko. I'm going to vote and I'm going to vote for who I like. And if I take your money, I will still vote for who I like. So that's the key point. Sorry, anything else?
Yeah, my lord, maybe just on the obiter, as I thank you for the way you have conducted the proceedings and the efficiency, also to bear in mind the timelines which the respondents are really given to respond to this, such a bulky election petition, a single 7 days. Some of the irregularities, my lord, which may go unexplained, could be because of this scarcity of time, my lord. Otherwise, it's to say that yes, my lord.
Do you put it in the report?
I did. I did, my lord. Okay. Otherwise, we take a lot of lessons as IBC, and we appreciate you a lot and your entire staff. Thank you very much, and even to council who appeared in this matter.
Yes, my lord. For the fourth respondent, we appreciate the pronouncement, except on one issue. I think Mongala has taken the bulk of the cost. Perhaps we'll have a discussion outside the court, if you can share something with us. Otherwise, my lord, we are happy in the manner in which you have conducted this petition. We are also happy with the judgment that you have pronounced today.
Of course you would be.
Yes, naturally. But on my part, I'm most impressed by the time you've taken to give IBC the teeth that it seems to have lost along the way. I think for me that's a very proactive judgment which will clean up the electoral practice in this country. Otherwise, thank you very much from the fourth respondent, and we do congratulate you, but my colleague has something to say. Thank you, my lord.
My lord, we welcome the well-reasoned judgment of this honorable court, which has really shed light on very pertinent issues that arose from the petition, and our client, therefore the respondent who is present, takes this opportunity to extend a hand of friendship to the petitioner now that the court has decided, and as we are aware, politics and democracy in their very nature are competitive, but it takes a wise soul to accept the electoral and judicial outcome in stride, and I recognize that Mr. Njiro is already in agreement with the position taken by this court, and indeed he says he wishes to go to the Court of Appeal to buttress the decision of this honorable court. So we are of the view that Mr. Njiro may want to take into consideration the will of the people, the constituents of Beere North, who would desire that going forward, the game moves from the court to the ground in terms of development programs, in terms of rendering of services, such that no more attention will be devoted to court proceedings. Therefore, the respondent has had a lot of distraction during the time when these proceedings were in progress. He had to shuttle between the constituency and the court, and that has unduly impacted on his ability to fulfill the promises that he made to his constituents. So we would be glad if this matter can rest at this stage. We continue to celebrate the wisdom of this court together with the petitioner, and it will be good for all of us, because sometimes you win, sometimes you lose, and even then the next election cycle is just 1 year away, and I'm sure our client, the further respondent, will be willing to make some considerations which would be favorable to the petitioner, depending on how the petition takes the outcome of these proceedings. Now, with regard to the prayer for the cost, we'll also be making an application that the amount deposited as security for deposit be released to the respondents.
Are you doing that application now?
Yes, because
I've already given the stay of 30 days. So
Yes.
even if you make the application,
Yes.
it will not affect the stay.
Very well. Then the amount can be released to the respondents on the 31st day. That's all, my lord.
Judge, we thank you for the detailed judgment and the way the court has conducted this particular petition. I as a Karaoke Njiri, I'm the senior most for the petitioner, and on behalf of the petitioner, we thank the court for the judgment. At the same time, to remind my colleague, Mr. Kamodo, that the petitioner and the four respondents are friends, and they will remain as friends, besides their political diversity. One issue, we would like the court to give directions on the electoral materials. My colleague had requested me to mention that, and also the keys that we are holding for the safe room going forward. We shall be inviting Judge Karudhoi to thank the court formally on behalf of our team.
I forgot to say anything about the electoral materials. Obviously, they will be returned, but let that come through a direction that I'll give the DR, which will, so I'm just saying directions on electoral materials will be given to DR to effect. Yes. Thank you for reminding me.
Thank you, my lord. I noticed today the role of the